Okay, good evening, everyone. This is Lynn Chipperfield. We're going to give everybody another couple of minutes to get online, and we'll get started as soon as they do. George, if you're there, could you just send me a message letting me know that you can hear me? Thanks. Okay, it looks like we still have a few people signing in, but let's get started so that we can try to stay on time here. Good evening to everybody. Thank you for being here. I like this way of communicating with webinars because it gives us an opportunity to get together in a way that doesn't involve the time and travel expense. It's always a nice thing to get together face to face with members of the fraternity, but on issues like this, I think this webinar is a good way to do it. I am going to be covering. This is Lynn Chipperfield. I'm the general counsel of the general fraternity. I'm going to be covering a lot of ground on this call. The slides that you see on your screen are going to be made available to you, so you don't have to take any time copying any of those. We're also recording this presentation, and that recording will be made available to you in the House Corporation Directory of Document Library in the officer portal, along with any documents I refer to. So you'll be able to find that posted in there shortly. I'm going to be doing most of the talking here, or all of the talking actually, until we get to the Q&A. But I also want to acknowledge up front that I don't have the kind of experience that virtually all of you have in operating with your house corporations at the local level. So I really have no idea, other than my own experience, of knowing whether an idea that sounds good from my legal perspective simply doesn't work at the local level. So if we get into territory like that, I hope you'll tell me in a nice way, and we'll try to get the right information out there. Tonight, most of what you'll hear is going to be focused on house corporations generally, why we need them, what's the optimal structure. Not going to get into a whole lot of detailed operating issues. That's a subject for a later call. The purpose of a house corporation will differ based on the nature of your housing. And for those of you, let me see if I can get this to switch slides. There you go. For those of you who whose undergraduate experience was focused primarily around living in a house, you may be surprised to see some of these numbers. Only 36% of our chapters actually own a house, 9% rent, but the most important number I want to direct your attention to is at the bottom. About 40% of our chapters either live in a designated area of a dorm, or they rent a lodge from the university, or they have no housing at all. And at the end of this call, I'm going to talk a little bit about that whole concept of housing, why it's whether it's necessary, whether it's even desirable. Most of the examples that I use tonight are going to be on the chapters that actually own a house, because that's frankly where we have the most issues and the greatest exposure. But don't feel left out if you lease a house from a third party, or you lease it from the university, or you have some other form of property, because much of this is going to be just as applicable to you as if to the chapters that own a house. I want to make it clear up front that there are no real mandates, or very few mandates. I'm talking to you as the general counsel of the International Fraternity, and with only a handful of exceptions, we don't mandate anything regarding house corporations. We very intentionally take a hands-off approach, both to alumni associations and to house corporations, because we don't want to have, frankly, control over their day-to-day activities, and we don't want there to be any perception that we have that day-to-day control. And we don't want to open ourselves up to the argument that these are all just de facto subsidiaries of the general fraternity, and that which could create liability obligations in either direction. There are really only three. These three absolute requirements are in our laws having to do with house corporations. Code 5-7B provides that before purchasing any real property, a house corporation must be formed under the laws of the state or province where the property is located, and it holds title to the property. That provision section also provides that they must obtain insurance and maintain the property. Code 5-7A says that each chapter and each house corporation must maintain appropriate financial records. And then the last one, Article 8, Section 7, has to do with what happens to the property of defunct chapters and their house corporations, and that property, net of assets, net of liabilities, goes into a chapter rehabilitation account. And we'll talk about that a little bit later. And then lastly, there's the requirement that everybody, the officers, the directors of our house corporations, have to go through the same certification and background check as our other volunteers. I'm going to be talking about a lot of structural issues with you this evening, but I want to start just by talking generally about why our laws require a house corporation. I acknowledge that for some of you this is going to be obvious and elementary. It's sort of like House Corporations 101, but just bear with me. There are two primary reasons why house corporations are required. First of all, you need an entity to hold title to the property. The chapter itself is really nothing more than an unincorporated association. For all practical purposes, it's not really a legal entity, although in some cases it can in fact be sue or be sued. It's just this group of unrelated individuals. Someone has to own the property, and a smart recorder of deeds is going to insist that someone's name or a corporation's name be on that title. Some chapters may ask, well, why can't it just be in the name of an individual alum or a group of alums? And I get a couple answers to that. First of all, that would be a violation of our laws, because the laws do require that you hold the property in the name of the house corporation. But more importantly, that would just be bad practice. We've all seen from experience that the dedicated alum, the dedicated volunteer who agrees to purchase an item of property may feel great about the fraternity now, but he may have a falling out with the fraternity, or he may die, and his wife or his heirs may have a lot less sympathy toward the fraternity than he did. The good thing about corporations is they have perpetual existence as long as they're maintained properly under state laws, so they aren't subject to mood swings or change of mind. So have it in a corporation. The second reason, though, limitation of liability, this is really the primary reason, and this is going to be the basis of a lot of the discussion that we have this evening. A house is generally the only significant asset owned by a chapter, and it's important to protect that house from exposure from any potential litigation against the chapter or against the Chapter Alumni Association. You'll hear me use this phrase, building a moat, and I do use that pretty regularly, but talk about building a moat around the house. Let me point out, and I always emphasize this to people, I want to be careful that we never let the legal tail wag the fraternal dog. I don't want anyone to think that the lawyers have now taken over and it's being run by lawyers. But if there are simple steps that you can take that don't interfere with chapter operations, and they don't increase the burdens on our volunteers, then it would make sense to take those steps. And those are the things that I'm going to be talking about tonight. This concept of building moats around various entities, that's to make sure that anything that may occur, incidents that may occur within one entity, don't give rise to liability on the part of other entities and lead to the attachment of assets owned by the others. If you want a more contemporary example, think about Las Vegas. Whatever happens at the chapter stays at the chapter, and it doesn't leach over to the other organizations. And it's no secret, as well, it's no secret to attorneys anyway, that corporations are very often used to isolate assets and to make it difficult or hopefully impossible for an attorney to get at your assets, or even frankly to be able to figure out who to sue in the first place. Most of the plaintiffs' attorneys who we deal with and who aren't familiar with the Greek system get very confused very quickly when you start talking about chapters and zetas and alumni associations and house corporations and the general fraternity, and sometimes they just give up, and that works to our benefit. There are basically 5 entities that I talk about that I want to keep isolated for liability purposes, and those are the entities listed here: the chapter, the alumni association, the house corporation, and then the general fraternity and the educational foundation. Separation of the house corporation from the undergraduate chapter is usually pretty easy to understand. There should be an arm's length contractual relationship between the house corporation and the chapter, with the house corporation leasing the house to the chapter, and then the chapter then entering into individual housing agreements with the members. We'll talk about that whole leasing structure here a little bit further down the road. If you maintain that separation, then if somebody does something stupid at a chapter, then the house itself won't be at risk. This is that concept of building moats that I talked about. And I have to qualify that by saying that's unless the house corporation has affirmatively done something wrong, like failing to maintain the structural integrity of the building or something like that. But that's a whole different issue. as you know, most chapters find a lot of ways to get into trouble that have absolutely nothing to do with the condition of the house. But some house corporations manage to build a bridge across that moat because they have undergrads as voting members on the house corporation board. And as laudable as that intention may be, and I understand all the reasons, it exposes the house to anything that might happen at the chapter level because of the deemed knowledge that the house corporation board has about what's going on at the chapter. There are ways to maintain chapter officer engagement in the house corporation without building that liability bridge, and we'll talk about that in a minute. There should also be a separation between the house corporation and the alumni association as well. And this, I know this is generally misunderstood because the articles and bylaws that I've seen almost invariably combine the two, with the house corporation being the official entity of the alumni association and with part of its purpose being to provide fellowship among alums and to aid and advise the chapter. And while there's generally, and I say generally, less likelihood that something bad is going to happen at an event sponsored by the Alumni Association, it has been known to happen. Remember, alumni associations don't have to comply with the same event planning processes that the undergrads do. They're all of legal drinking age. And sometimes just the mere act of walking back onto a college campus makes us all fall back into old patterns of behavior that could give rise to incidents. So remember that if you combine the house corporation with the alumni association, then the house is exposed to liability for anything that might happen at an alumni sponsored event. The purpose of a pure house corporation is to build a liability moat around the house so that if something bad does happen, the house won't be deemed an asset of the alumni association and it can be protected from litigation. I also isolate, for liability purposes, I include the general fraternity and the educational foundation. As I said earlier, there are very few provisions in our laws dealing with house corporations. We take that hands-off approach for the reasons that I stated earlier, so that we won't be deemed to have subsidiaries and that sort of thing. Because the general fraternity and the educational foundation, quite honestly, that's where the money is. And you can imagine how much a plaintiff's attorney would like to get his hands on the assets of not just the general fraternity, but particularly the foundation. So this is why I'm always very careful to tell chapters and alumni groups that I'll offer them all the help and all the advice I can. But at the end of the day, I represent the general fraternity and not them. And so far, we've been successful in having the general fraternity dismissed from cases involving chapter activity, and the law in most states is very good for us in that regard. Unfortunately, Maine is an example of a state where the law went the other way. But for the most part, it's easy to get us dismissed out of the lawsuit. It doesn't keep us from getting sued in the first place, but the general fraternity can usually get out. But maintaining that legal separation is very important. So this is really the meat of the presentation. I want to talk about some nuts and bolts. There's some things that you should know about the best way to structure and manage a house corporation. And there's several topics here. And as I said, these slides are going to be made available to you, so don't bother writing all this down. A house corporation has a very singular set of purposes. It owns the house. And in that context, it does things ancillary to owning the house, like it pays the mortgage, it purchases property insurance, pays utility bills, taxes, professional fees to make the appropriate filings, that sort of thing, hopefully establishing a reserve so that it can provide routine maintenance and plan for long-term replacement. But the house corporation isn't the alumni association, as I said before, and it's not the alumni advisory board. It doesn't advise the chapter. The house corporation doesn't run the chapter. Our laws already require that each chapter have an alumni advisory board appointed and chaired by the High Pi. And the people who serve as officers and directors of the house corporation and those who serve on the alumni advisory board, can be the same people, possibly not 100% alignment, but you can have some overlap there. This is the place where most of our house corporations screw it up and it starts in their statement of the purpose of the corporation in its articles of incorporation. And I'll give you an actual example from one of our long-standing chapters, a chapter that's been out there for more than 100 years. Here's what it states is its purposes in the articles of incorporation of its house corporation. And just tick through these. They're to promote and further the welfare and interest of all members of the Zeta, past and present. So they've just built a bridge across the moat between the house corporation and all of its members. Encourage sound undergraduate chapter management through advice and counsel. Again, this is a bridge to the undergraduate chapter. Provide continuity for undergraduate chapter operations. Coordinate and plan all alumni activities. You can see from my earlier comments how the distinction between the house corporation and those other entities is beginning to blur with all these. And then finally, last and apparently least, it's the one purpose that the house corporation was supposed to be there for, and that's to provide and maintain a house for the benefit of the undergraduate members. These are actually taken from a set of articles that I've seen. So you can see how many encroachments we have there on this separation between the two. I have my own template in the form articles and form bylaws that are posted in the document library. And it's very straightforward. First, it says that this is the first purpose is whatever the purpose is of a Section 501c7 corporation. That's pretty clean. Not perform any activities that are not carried out by a corporation formed under 501c7. And then just this one sentence: the primary purpose of the corporation is to own, lease, maintain a house. Period. That's it. If you want to have a separate organization, or frankly even a separate corporation, to operate the alumni association, to sponsor alumni events, to advise the chapter, that's great. It won't have any assets, so it's judgment proof, which is always good. But don't embed those functions in the house corporation. Keep the house corporation simple. I mentioned earlier, but while I'm on this topic, when I say you should have a separate house corporation with separate officers and directors, and maybe a separate alumni association, even a corporation with separate officers and directors, and you have an alumni advisory board, I get the question sometimes from chapters, well, where are we going to find all these volunteers? We're having trouble just finding a high pie. And the answer is you don't need that many people. In my example, you probably just need 3. Whatever the statutory minimum number of directors for a nonprofit corporation under your state's nonprofit law, and they can all be the same guys. But the only important thing is, and this is critical, is that those volunteers always remember what hat they're wearing at any given time while they're engaged in an activity. If you have the same people on the house corporation board as on the alumni association board, or serving on the alumni advisory board, probably about 5% of your time is going to be taken up with worrying about the house, and the rest of it is you're going to be in your capacity as a pure chapter volunteer. So just make sure you understand when you're doing certain things in what capacity you're doing it, but you don't need 20 volunteers to populate all these things. You just need a solid core of individuals. So that's the first step. Keep the house corporation purpose focused. Most state nonprofit corporation laws allow you to form a corporation without members, and I've seen this one that I mentioned before with that broad spectrum of purposes. It also had a huge board. I think it had a board made up of something like 14 members. And you don't need to do that. But the members of a corporation, there's a distinction here, and this is important. The reason state laws allow you to have one without members is because if you do have members, then the state laws kick in, and there are a lot of protections that arise for the members of a nonprofit corporation. Um, and they're there to protect the interests of the stakeholders. But what those state nonprofit law rules do is they significantly complicate your life because you have to keep track of all these members. There could be thousands of them out there. So form your nonprofit corporation without members. Now, there is a wrinkle here, and I want to make this clear because this is very important. Substantially all of the income for your house corporation is going to come from rent or other charges that are being paid by the undergraduate members. The provision, the Internal Revenue Code provides that no more than 35% of the income of a 501c7 corporation can come from non-members. So if you follow my advice, and if the people who are in the undergraduate chapter aren't actually members of the corporation, then that could mean that you're getting more than 35% of your revenue from non-members. But there's a simple fix. There's a simple way to handle this. And it's incorporated into the language that you use to define members in your form, articles, and bylaws. And this language that I just put up here is in the form, articles, and bylaws that are available to you. And basically, in summary, what it says is that the corporation shall have no members, as that term is defined in the state nonprofit corporation law, but it may have members as defined in section 501c7 of the code. And this language has been vetted, and it's good. I mean, attorneys have taken a look at this. And the designation as a member for purposes of section 501c7 doesn't entail any of those people to the rights of membership under your state law. So there's two different laws here. One is the federal and one is the state. And there's a way to comply with both and avoid that 35% limitation. So as long as you've got your membership set up right, don't worry about that limitation. That's a red herring, and it won't bother you. I've mentioned this before. Too many officers and directors. Keep it simple. Most state nonprofit laws, most state corporation laws, generally only require that you have a minimum number of directors. Sometimes that's 3. Go with as few as you can. I mentioned that corporation that I looked at before. It had a 14-member board, 5 of whom were required to be undergraduate officers, including the High Alpha, the High Tau, the High Rho, the House Manager, the High Pi. At least I think that included them. It was unclear. Maybe it's 10 undergraduate members. I don't know. But keep it close to the statutory minimum, like 3, so you can hold quick and uncomplicated meetings. You can gain a quorum. You can gain approval quickly whenever you need. And then the officers should be only those that are required by the state statutes as well. And generally that's a president and a secretary, and sometimes a treasurer, but not necessarily anybody else. So if you can do this with 3 directors and 3 officers, all of whom can be the same people, you should do so. Try to keep it as uncomplicated as you can. Have meetings only when you need to. Don't overburden your volunteers. In most states, 1 annual meeting is sufficient to preserve the corporate structure, where you have an annual meeting and you elect directors, and those directors then have an annual meeting and they elect the officers, and everything's just great, and that's it. In some chapters, particularly those that have substantial properties and lots of housing issues, you may have to have monthly or quarterly meetings if you have to. But you should try to reduce the burden on the volunteers to the extent you can. If you have meetings of your alumni association, just tack a house corporation meeting onto the end of that, just so long as it's distinct. We're now moving into a house corporation issue, that sort of thing. And that should satisfy your requirements for having your meetings. But try to keep them as limited as you can. Minutes and corporate records. Lawyers will always tell you there are significant advantages to being incorporated. It limits liability of officers and directors, but, and this is a big but, the failure to maintain the corporation through appropriate meetings and appropriate filings with the state could result in the denial of corporate status and personal liability for the officers and directors. Lawyers call this piercing the corporate veil. It sounds painful. It's meant to sound painful because it is. Have articles, have bylaws, minutes of meetings, annual reports. These are all critical to maintaining the corporate entity and affording yourselves the protection of the corporation. The documents don't have to become complicated, and the minutes can become boilerplate over time, but they have to be maintained. Now, some of you are probably asking yourselves, well, this sounds like a lot of form over substance, and you're absolutely right. It is form, but when it comes to maintaining corporations that have assets that an attorney's trying to get his hands on, form is everything. Your corporate records and your corporate filings would be the first thing that a plaintiff's attorney should ask for if he knows what he's doing. Along with that, make the appropriate annual filings. Look at your state law. At a minimum, these are going to require the filing of an annual report with the Secretary of State of your state in order to stay in good standing with the state, and it will require a filing of an IRS Form 990 to maintain your nonprofit status. You might want to make a note that our fraternities laws, that is one other requirement, is the filing of a timely IRS Form 990 if required by law. So just be sure at least those two, and then there may be some others in your state, and you could take a look at that. I mentioned this before, but it's worth repeating because I'm guessing that nearly all of our house corporations have made this mistake. The high alpha, the high tau, the high rho, maybe the house manager, maybe the high pi, they can and perhaps should attend the meetings of the house corporation, but only as a resource to the house corporation, not as officers, not as voting members, ex officio members at best. Maintain that legal distance from the chapter itself, because the house corporation may wind up with deemed knowledge of what's going on at the chapter. This issue, just as an aside, this issue of putting students on house corporation boards isn't theoretical. The general counsel at Sigma Alpha Mu, Sammy, told me of at least one case they had in which a 5-figure settlement was required solely because they had a student on the house corporation board as a voting member. It makes a difference. It's not just theoretical, so don't do it. This one, it may sound simple, but it happens. This is always sign contracts in the name of the corporation in your representative capacity, not in your individual capacity. Most of you have probably seen this sort of a signature block. Name of the corporation by your name, your signature, and then your title under that. Failure to sign this way expressly on behalf of the corporation could give rise to some personal liability. This isn't theoretical either. We had a case relatively recently where a chapter leased its house from the university. There was an incident at the chapter house where someone sustained some damage, and that individual sued both the chapter and the university. The lease between the chapter and the university required the chapter to, or the house corporation in this case, to indemnify and reimburse the university for any fees that it had to spend in order to get out of this house. Now, an individual had, their house corporation was the party to the lease, but the house corporation had fallen out of qualification. They hadn't made their filings and that sort of thing. So an individual, not knowing that, signed personally as the lessee. And the university went to him and said, "You are personally liable." And it was a solid argument, a 6-figure request for indemnity. So don't get yourself into that position. I talked a little earlier about the lease relationship, where the house corporation leases the property to the chapter, and then the chapter turns around and enters into agreements with its individual members. you should have a lease between the house corporation and the chapter. In fact, I like that sort of thing because that establishes even more this arm's length relationship between the two entities, between the house corporation and the chapter, and it builds that moat. It separates the two. But when it comes to the agreement between the chapter and the individual members, this shouldn't be in the form of a sublease. It should be in the form of a housing agreement. And I use that word housing agreement intentionally. Using a lease or a sublease brings into play the various landlord-tenant laws in individual jurisdictions. And you should want to retain more flexibility than the landlord-tenant laws provide. So you should avoid words like lease, sublease, landlord, tenant, rent, security deposit. Use other words, other contractual words. I'll give you an example just to show why this can become significant. That we had a chapter where on their way out the door after the spring term, a bunch of members did a significant amount of damage to the chapter house. And then it took a long time to figure out not only how much the damage was, but how to allocate that damage properly among the individual members. And by the time, and then when they did that, they took it out of the guy's security deposits. So that means they withheld the security deposits for a long period of time. Well, by the time they figured this all out, the 90-day statutory deadline for returning security deposits under the landlord-tenant laws had run. And they faced the possibility of having to return double the amount of security deposits because that's what the law provides. If you have a housing agreement, then you don't have that issue. Now, I will acknowledge that there is some room for honest disagreement among attorneys about whether you should make these subleases or housing agreements. Those who favor subleases are going to argue that there's a broad body of law that covers landlord-tenant rights, and you can take advantage of that rather than to have to deal with contract law, which varies from place to place. And another reason is that the landlord-tenant law can offer a more simplified and expedited process. But my reasons for advocating for housing agreements instead of leases are two, in addition to what I've already said. First of all, yes, the landlord-tenant law is well established, but it's generally very pro-tenant. That's why the laws were passed in the first place. The landlord will always have an uphill battle against a dispossessed individual in court. And remember, it's usually the tenant who's trying to assert his rights. So we have no interest in an expedited or simplified process. We want to stretch that out as long as we can. And not give the tenant the benefit of the landlord-tenant laws. My second reason for favoring housing agreements over subleases is that, frankly, I don't believe these are leases anyway. Leases have a demised premises where the boundaries are defined, generally some sort of exclusive rights to use. Our agreements with the undergrads give them this sort of broad, non-exclusive, loosely defined access to the house. And most of them, some of them, don't even mention any particular room in the house. That's sort of tacked on later when you do the room assignment. So I think at best, it's not a lease. It may be a license agreement, but that's it. There's another reason, and I think this is something that you may not be aware of. There's a provision in the laws of many states that makes the landlord-tenant laws inapplicable to fraternity houses. And this one, just Indiana, for an example, it's very straightforward. The residential landlord-tenant statutes don't apply to any member of a fraternal social organization who's living in a structure operated for the benefit of that organization. It's very straightforward. Now, I don't know how many states have this. I can tell you I did about a 10-minute Google search and came up with 5. It may apply in your state, it may not, but it's still out there. And so maybe these aren't leases because they're just not covered under the landlord-tenant laws to begin with. But I wouldn't rely on this. I wouldn't rely on that law. Call your document a housing agreement instead of a lease. Get rid of all those lease-related terms. And I've suggested to a number of chapters that they actually add a provision in the housing agreement that basically says this isn't a lease and the landlord-tenant laws don't apply to this. Put it in the contract that this agreement does not constitute a lease. And then the bracketed language at the bottom, if you find that the laws of your state, that the landlord-tenant laws don't apply to fraternity houses, recite that in the document as well. There's no reason why you shouldn't. Now, I'm a realist, and I know that there are courts who are going to look to the substance of the relationship rather than what you call it. They may treat this as a sublease, regardless of what you say it is. But as I said, I'm not convinced that these are truly leases. And in any event, if you've got this in your agreement, at least you've preserved the opportunity to make the argument. I was asked one more point on this. I was asked recently, just a few days ago, in fact, if a member is suspended by a chapter, but he has a lease agreement with the house corporation, can the chapter require that the member move out of the house, or would that represent some sort of interference with his contractual relationship with the house corporation? In other words, if we suspend a member but he's got a lease, can we throw him out? First of all, I would note that our laws under individual member discipline provide that a member who is suspended must remove himself and his belongings from the chapter property. That obligation is an obligation to the fraternity, wholly unrelated to his lease agreement with the house corporation. It's fully enforceable by the chapter against the member, even if his lease gives him the right to stay. This suspension may cause him to breach that lease, but that's his issue, not ours. It doesn't affect the chapter right. The second thing is I always recommend to chapters with housing contracts that they include a provision, and I've got some language here that specifically states that when a member is suspended or expelled or on probation, and those are the terms of his probation, or in the event chapter operations as a whole are suspended, then he's out. He got to leave the house and take his personal effects with him. I think this provision should be in every lease between the house corporation and the chapter, and in every housing agreement between the chapter and the individual members, so that there can be no argument that the chapter doesn't have the right to throw this person out if he's disciplined in some way. I know a lot of you don't own a house, you lease, either from the university or from a third party. And the question then becomes, do we need a house corporation? Note that the fraternities laws that I mentioned before, only require the formation of a house corporation if you build or purchase a house, not when you lease. This is an open issue. My advice is to enter into the lease with the university or with the third-party landlord in the name of a house corporation. Then have the house corporation sublease to the chapter if you want, or to the individual members, but which I don't recommend. There are reasons why a house corporation would be desirable from your perspective and from the third-party landlord. If I were a third-party landlord, I wouldn't want to have a lease with some strange group of guys that's going to turn over every 4 years. I want to have a lease with grown-ups where there's adult supervision and somebody to collect the rent and somebody to maintain the property. So the third-party landlord very often will ask or will require that you have a third party, that you enter into this as a house corporation. So think about that. That's just for some of you who have a lease, and I acknowledge that there are some universities that probably won't let you do that. They want to have a direct housing agreement with the chapter or with the individual members if, for example, they pay their room and board through tuition and related payments. But if you can, it's something to think about, having a house corporation, even if you just lease. Those are sort of the nuts and bolts. I've got a couple of additional things that I want to comment on, but I would encourage you, just based on what we've already talked about here, to go back and take a hard look at your articles and bylaws of your house corporation. Take a hard look at the relationships that you have with the chapter or the individual members, either a lease or a housing agreement, and consider the ways that you can use some of this information both to simplify your operations, make it less complicated, and to further protect the house from liability for what happens at the chapter or at the Alumni Association. I mentioned that I've already prepared some form articles and bylaws for a house corporation. I've also prepared form articles and bylaws for an alumni association if you want to incorporate a separate entity to do that. And those will be available on in the document library. So just a few sort of miscellaneous thoughts before we turn to questions and answers. First of all, I mentioned this in Article 8, Section 7 of the Constitution, the requirement that all property of a defunct chapter and its house corporation, net of any outstanding liabilities, all net assets, at the time it's terminated, pass into a chapter rehabilitation account under the statutory code. There's also the requirement that this provision be included in the articles and the bylaws of each house corporation, and they are included in the forms that I've posted online. If this should come to pass, then there'll be a separate written agreement with the general fraternity, and between the general fraternity and the house corporation that will specifically detail the terms and conditions of what would happen with that house. I'm going to tell you what you probably already know. The general fraternity is generally not in the real estate ownership or leasing business, and we would prefer not to be, and not to take title to the house if the chapter ceases operations. We did have an experience with that in the past, and it wasn't a good experience. So the monies what would go into the chapter rehabilitation account would be the cash after conversion of the property, after the sale of the property, after it's converted into cash, and then that would be held for the future reestablishment of operations. I have put together a form of a chapter rehabilitation account agreement that I may propose that we enter into with each of our house corporations that owns a house. Generally, it's better to do these things now while people are still talking to each other rather than waiting until a chapter has been closed and everybody's emotions are high and everybody's on edge. And the provisions of that agreement give a lot of flexibility to the house corporation. The house can be either retained or sold in the sole discretion of the board of the house corporations. In other words, the board can elect to retain the house, continue to operate it as rental property, and preserve the income from the house in trust for the chapter pending the reestablishment of chapter operations. Or the board can sell the house, and then the proceeds of the sale of the house would go into this chapter rehabilitation account to be held for the reestablishment of operations. Now, there is a 20-year time limit on this for owning the house separate and apart from reestablishment of operations. But we can get into that. We'll have some further discussions about chapter rehabilitation accounts at a later date. I want to make mention of this. There's a memorandum that is or will be posted in the document library about the distinction between 501c2 and 501c7. Section 501, generally, of the Internal Revenue Code exempts certain nonprofit organizations from federal taxation. For example, the Lambda Chi Alpha fraternity, the general fraternity, is exempt under 501c7, which covers social and recreational clubs. Donations to the general fraternity, as you know, are not tax deductible. The Educational Foundation is tax exempt under 501c3, which is for religious, educational, charitable organizations, and those donations are tax deductible. But there's an inconsistency among our chapters about the subsection of 501c under which a house corporation should be qualified. A lot of chapters have qualified these house corporations under 501c2, which applies to corporations and associations organized for the purpose of holding title to property. So it sounds like that would be the one. It's sort of an attractive nuisance. It's just sort of, you look at it and you think, yeah, that's the one, because this is organized for the purpose of holding title to property. But house corporations should not be C2 corporations. They should be C7 corporations. And I won't get into all the statutory reasons for that. You can read the memorandum that's posted online. But you should be a C7, not a C2. Now, some of you may already be a C2. You can convert to a C7. There's a process for doing that. It's generally costly. It's generally time consuming. The better way to do it is simply to create a whole new corporation qualified under C7 with newly drafted organizational documents, something that you may well need anyway, and then have the C2 deed the property to the C7 and you're clean, rather than going through that conversion process. All of this is beyond the scope of our conversation this evening, but something to take a look at. Don't incorporate as a C2. Make sure that you're a C7, and don't make your C2 corporation a subsidiary of your C7, because that doesn't get the house out of the C7. It just don't do it. A comment about 501c3, and I'm sorry that all these Internal Revenue Code sections and all that, but this is important. A 501c3 corporation can only use funds for educational and similar purposes, and deductible donations to a house can only be made to the extent they pay for those portions of the house dedicated to educational purposes, like the library, study rooms, that sort of thing. I mention this because some people think, well, we'll just form a C3 corporation and we'll buy and build a new house and everything will be great and all the donations will be tax deductible. They're not. And one of the reasons I mention this is because these days it's very, very easy to form a 501c3. The IRS has put together this new form. It's called a 1023-EZ, where you basically self-certify. You say, I'm forming a C3 corporation and I agree to obey the laws. And literally 6 days later, you've got your C3 qualification. I think that's dangerous. I think there are going to be a lot of corporations out there who are going to get that status and they're going to begin taking what are actually non-deductible donations and telling people they're deductible, and people are going to get in trouble with that. So if you want to form your own qualified chapter level C3 corporation, go ahead, feel free. I'm not sure if you can, because frankly, I don't think the beneficiary class is going to be broad enough. But if you can, great. I won't give you any advice on that. I mean, you're going to have to seek some real quality legal advice if you're planning to go down that C3 path. I want to make a comment about directors and officers liability insurance. There is a wrinkle in our D&O policy that you should know about. All of our certified volunteers, and that includes all of you, are protected under our general liability policies and under the Federal Volunteer Protection Act. As a house corporation volunteer, whether you are covered under our D&O policy and our commercial crime policy depends on where you get your property insurance. You're an independent corporation. You can get your property insurance anywhere you want. A number of our not a lot, but several of our house corporations get their insurance through an agency other than the fraternity's usual insurance provider, the Favor Company. What you need to know is that if your role is as an officer or director of a house corporation that is not covered under the Favor property insurance, you are not covered in that capacity under our D&O or our crime policy. You're covered for general liability, but not D&O or crime. So you want to take that into consideration. You can handle that in a number of ways. You can either elect to go without D&O or crime insurance, which I wouldn't recommend. You can secure a separate policy of D&O and crime coverage through a separate insurer, or you can switch your property insurance to the favor agency, and they would then be providing you coverage under our D&O and crime policies. Not encouraging one way or the other. I'm just letting you know so that there's no surprises about D&O and liability insurance. I added this last sort of miscellaneous observation because I got a question about it recently. In this past August, the state of Texas passed a law requiring every public university in the state to allow persons who hold concealed handgun licenses to carry a handgun both on the grounds and in the buildings of the university. I don't want to get into a Second Amendment conversation here, but that law says it's subject to reasonable rules and regulations, and the universities in Texas are in the process now of trying to figure this out. Nationwide, probably all of our states have some form of either open or concealed carry law, including obviously all the states where we have chapters. Whether these laws apply to your house may depend on whether your property is owned by the university or not. I should direct your attention to the fraternity's laws about firearms, that the possession or use of firearms, explosives, incendiary devices at a chapter house or at any chapter property or at any chapter event is prohibited. But you also may want to take into consideration these concealed carry laws. Most of those laws provide that private businesses, which is what we are, can forbid people to carry firearms onto their property. Sometimes it requires that you have to post something at the entrance in order to let people know that the firearms are not allowed. So I'm not an expert on this. I encourage you to investigate it on your own. My only observation from the fraternity perspective is that mixing firearms with young men, with young women, and alcohol is a incendiary mixture, and you may want to think about whether it's in the best interest of your house. Very quickly, I just want to mention these three other alumni structures besides the House Corporation. An alumni association, this is not required under our laws. We take a hands-off approach, as I said earlier, to these. These are to provide fellowship opportunities for alumni members and often undergraduates. You may want to incorporate this association. You probably should, because if you sponsor an alumni event sponsored by the Alumni Association and something goes terribly wrong and somebody gets hurt, if you have incorporated the organization, they sue the corporation, which is generally judgment proof because it's got no assets. If you're not incorporated, then individual members may become liable. So it's probably a good idea, if you are in the business of sponsoring alumni events, to have a corporation. Alumni advisory boards, as I said, are provided for in our laws. The High Pi has the obligation to appoint and to chair an alumni advisory board. They're to lend guidance and advice to the chapter. This is a separate entity. This is not the Alumni Association. An alumni advisory board is a separate entity, although it could very easily consist of the same people. Don't think about incorporating an alumni advisory board. There's no need to do that. It's not required under our laws, and I don't think under common sense either. But keep in mind that the middle word there, advisory. The role of an alumni advisory board is guidance and advice. The Alumni Advisory Board does not control the chapter. It doesn't get engaged in controlling their day-to-day operations. Be careful with that, because once you start getting involved in day-to-day operations, you may be getting into the liability soup, and you want to try to avoid that. The third one is an Alumni Control Board. Any of you who have had experience with this know that this is an authority that comes from the Grand High Zeta when a chapter is in serious trouble and in need of alumni control. There may be some overlap between the Alumni Advisory Board and the Alumni Control Board, but this is a very different entity, and hopefully most of your chapters won't be involved with that. I said earlier at the very start that there are a lot of our chapters that don't own a house, and maybe you don't, but you're anxious to buy or build one. And if this is the case, then I have 3 things to tell you. Housing isn't essential. In many cases, it's not desirable. And there are lots of ways to provide housing opportunities and other chapter-related opportunities that don't involve the purchase of a house. As I said, about 40% of our chapters have no house. And while some of you may be wondering, how do you have a fraternity without a house, because that's been your experience, many of these 40% are consistently among our best performing chapters. Now, I understand the cultural differences on various campuses that make a house desirable, or where the members or the alums are convinced that they can't compete on a level playing field in recruitment if they don't have a house. But I'll tell you, many of you may already know this, that a house generally creates problems. It doesn't solve them. It distracts members and the alums with property management issues. It can detract from the fraternal experience because the house has become a substitute for or a symbol of the brotherhood, where chapters that don't have a house have nothing to fall back on but brotherhood. They don't have the house. You should also know that housing is different today than it was when we were there. There's no longer just that one telephone line, and scheduling conflicts often make the group meals less common. They don't have hallways of rooms with a group shower down at the end. That's all given way to suites where small groups have their own individual living spaces. So it doesn't provide the same sort of group life and bonding experience that it did in the past. So my point here is, if you don't have a house, think long and hard about whether it's really what your chapter needs in its current state of operations. I always use this example. It's like a couple having a baby in order to preserve their marriage. It doesn't work most of the time. So think about it. If you're bound and determined to own a house, take into account all the suggestions that I've made on this call. And if you're going to be soliciting donations to buy a house, be sure to make clear the fact that those donations are not generally tax deductible unless they're to a bona fide C3, and that they're for the educational elements of the house. How are we doing? Okay, just about an hour. That's good. Those are all of the prepared marks that I've got. I know we've covered a lot of ground, and I'd be pleased to take any questions that you have, and you can post your questions in the little box there in the thing, or raise your hand, and I'll see if I can get to you. But at the risk of getting too bogged down at this point, because I don't want to keep you going too late, maybe it would be a good idea for all of you to absorb this information, what we've all talked about tonight, and analyze your own articles, your own bylaws, your corporate structure, your leases, your housing agreements, in light of all these suggestions, to see how far behind the curve you might be. And then maybe we can set up a follow-up call so we can discuss questions that have arisen. If you want, you can email me. My email address is here. Email me with any specific questions you think might be broadly applicable to others, and I can put all these together over the next week or so and get a frequently asked questions document out so that we can try to answer all of these questions. I'll certainly take any questions that you've got right now. I do have one. I got an email earlier that had 2 questions, and one of them I think I've already answered. How do we structure the house corporation where its primary income comes from members, but the IRS requirement for nonprofit is that it has to be you can't derive all your income from non-members. I think I answered that earlier in the context of the difference between the federal requirements and the state requirements. And then the second question, I hope I've also answered, and that is, can the general fraternity help on a state-by-state basis to ensure that our written corporate documents meet both state and federal legal requirements for 501c7? I'm going to give you half an answer on that one. Federal, yeah. That doesn't change around the country. Whatever the federal rule is on 501c7, I can help you with that. I am not specifically, affirmatively not going to become an expert on the nonprofit laws in all 50 states. The form documents that I've given you should satisfy the law under your individual state law. But my recommendation is find a brother who's an attorney and who's willing to donate a little bit of time and review the state nonprofit laws to make sure that you're things like your required state filings, whether your nonprofit laws require members or if you can go without members, the number of directors, that's the minimum number of directors that's required. I would suggest that you have somebody take a look at that. So I'll help you with the 501c7s, but I got to beg off when it comes to reviewing the questions about all 50 states. Okay, I got a bunch of questions here. Hold on just a second. Okay, I gotta see if I can make this bigger because these questions, okay. Okay. Included, I can hear your audio, see the screen. Okay, just a second. I got some back. There's all kinds of conversation going here. I just saw something about the Gazzoni brothers. Don't ask me about that because I don't want to talk about those guys anymore. If the chapter is not an entity, how does the lease to that association give you protection from liability? Well, it does. Because you've created that distance. It's not the issue there is not, is the chapter capable or not capable of entering into a contract? They are. I mean, they can bind, an unincorporated entity can usually bind itself. The importance of entering into that agreement, though, is maintaining that separate legal distance between the two. Question, this means that 3 tax returns and books. Yeah, it could. I mean, if you want to have an incorporated alumni association, you will have a set of books for the house corporation, clearly. You'll have a set of books for the chapter. It doesn't, as I said, it doesn't have to be complicated. Maintaining a corporation is generally an annual thing where you make sure your filings are done. What my point here is not to make your lives more complicated, it's to make it safe. And if there are some relatively minor things that you can do to provide for that, then you'll be in better shape. Maine allows for a corporation without members. I don't know. You'll have to check with the law in Maine. What makes up an annual report for a house corporation? Go on the website for your Secretary of State in whatever your state is, and there'll be forms online. Very, very simple. Usually, what you do is you just list whoever your directors are and maybe what your fiscal year end, and it's very simple. It's just so that the corporation has a way. There's sort of a process by which corporations can dissolve without the state having to chase them around. If they don't make these filings within a certain period of time, then they can dissolve automatically. Should we obtain, insurance for directors and officers? Yes, I would. If you're insured already through the favor agency, you already have it. If you're not insured through the favor agency, and I'm talking about your property insurance here, forget about the chapter. I'm talking about the property insurance on the house. If it's through an agency other than favor, then you should probably go out and see. My guess is that it would be relatively inexpensive for a corporation like this. And of course, you can, as with all things, you can build it into the rent. Did you say the high pi should not be a voting member, officer, director of the board? Yes, I did. The high pi is a chapter officer. And there's also a concern, I'm less concerned, but there is a concern that the high pi is actually appointed by the grand high pi. So you're kind of, if you have the high pi on your house corporation board, not only are you linking the house corporation to the chapter, but you're linking it to the general fraternity as well. I would recommend that the high pi attend house corporation meetings, but attend either as a resource or at worst as an ex officio member of the board with voice but no vote, without the right to vote. I would frankly prefer it as a resource, but you can. I understand that there are issues, political and otherwise, at every chapter where individuals want to have it different ways. But that's my overall recommendation. Should the chapter own, administer the housing agreements as opposed to the house corp? Yes. Because I think you will want the house corporation to be collecting one check. You don't want to be chasing individual members for their rent. You should have an agreement with the chapter where the chapter maintains those relationships with its members, so that the chapter, if the chapter owes the money to the house corporation, it's going to have to pay notwithstanding, and then it's up to the chapter to go put the arm on the individual members. And I think that you're going to be much more successful if the chapter is going after a guy for unpaid rent than you will if some nameless, faceless group of alumni in a house corporation are trying to go after this guy. So the answer, if that was the question, the answer is yes. I would have the chapter administer the house agreements with the individual members. Okay, you repeatedly mentioned things like the chapter can do one thing or another. If the chapter is not an entity, how does this work? Well, the chapter, it's an unincorporated entity. I would, if I were a plaintiff's attorney, I'd get a little nervous suing a chapter because I know that it's just a group of guys. But that doesn't mean that the chapter doesn't have the power to obligate itself. And that's all handled not through the High Zeta, but through the executive committee. The executive committee is essentially the board of directors of a chapter. The Grand High Zeta, or the High Zeta, if you look through our laws, really the High Zeta as a body has no power at all. It's individual officers, but the High Zeta doesn't have power. It's the executive committee. So the executive committee and the officers, they have the authority to bind the chapter. The question becomes, how do you enforce that against an organization that really has no assets other than its members? But they still, it still works. What is D&O or crime insurance? Oh, D&O. D&O is for directors and officers liability insurance, and it's to protect you while you're operating in your capacity as a director or an officer of a corporation. And this applies everywhere for both for-profit and nonprofit organizations. A lot of times attorneys will sue individual boards, individuals on a board of directors. Sometimes it's a tactical thing just to get their attention and try to force some sort of a settlement. But directors and officers liability insurance covers you for acts undertaken in the course and scope of your duties as a director or officer of a corporation. Now, if you steal or do something else that's outside the terms, you're not going to be covered for that. But that's generally what D&O coverage is. And I do recommend, even if you don't get your insurance through favor, I do recommend that you look into what you might have to spend for a separate D&O policy. What is the coverage limit for my term under the general fraternity? Our general liability insurance has $5 million is a $5 million policy, so you would be covered under that. I believe that still applies. If not, Justin or George or somebody can correct me. But the coverage limit under the fraternity's general liability policy, which also covers house corporation officers, is is the same 5 million. I would suggest that you mention that the sample articles and bylaws are just that, samples. You are not providing legal advice, and each association should obtain competent legal counsel familiar with state law. For instance, in Illinois, a nonprofit corporation may have a set number of directors or range, but the range may not be greater than 5. Each state has its own quirks. Sample forms are not intended to take these into account. So have a lawyer familiar with nonprofit corporations take a look. Absolutely. Absolutely. I may have made that point earlier, but I want to emphasize that you need to have some competent legal advice, some brother who's willing to volunteer some time to take a look at your state nonprofit corporation law. A lot of them are the same. They all start to look the same after a while, but this is a template. This is a form, and it may need to be tweaked. And so, I absolutely agree with that. That you should have somebody take a look. Thoughts on CSL management, like companies offering Greek housing and operations management. I don't, that's a little bit beyond this. I mean, I kind of intended in this conversation to talk about structural and bigger sort of issues. I didn't want to get bogged down in operations issues, but I know that that's a primary concern of yours. I don't have an opinion, quite honestly. I don't have any experience with various property management groups. But you should have the house corporation should have some sort of either manage the property itself, which is probably not doable in most situations, or enter into a separate property management agreement, or enter into a contract with the alumni association to manage the property. I had somebody ask me one time if these are separate entities. How do you get money out of the house corporation and into the hands of the alumni association if they want to sponsor an event of some sort? And my response was, enter into a contract, have them manage the house for you and pay them for it. And you use that. That's one way to transfer money. Otherwise, that money's got to stay in the house corporation. I'd be a little careful with that because I don't want, your house corporation shouldn't be run at a profit. It should make enough money to set aside reserves to replace the house or repair the house. But I get a little antsy when people start talking about overcharging the undergrads so that they can fund other activities and alumni things. So I'd be a little careful with that. But on the property management side, I just don't have an answer for that. Okay, so just someone mentioning again this revelation that you may not be covered by D&O if you're not covered by favor, saying they're going to send in to get a quote. That's good. Okay, it's okay to have the same individuals on an alumni advisory board and a house corporation as long as they wear the right hat at the right time, but I've heard it's not good to have common members between a house corporation and an alumni control board. Is that correct? We found it to be beneficial to have one or two common members to serve as liaisons. Should they change to guests or ex officio? I got to tell you, when you get into an alumni control board situation, you got bigger problems than worrying about, who the directors are. So I would say, if you've got a qualified alum who should be appointed to an alumni control board and just happens to also sit on the house corporation board, I wouldn't lose any sleep over that at all. At that point, frankly, that chapter is so far off the rails that worrying about these somewhat technical liability issues and building bridges between organizations should be the last of your concerns. So the short answer is no, I don't. If someone is qualified to serve on both, and you do get into an alumni control board situation, go for it. Our chapter has a 501c3 leadership foundation. Are there pitfalls to having this organization function as the alumni advisory board? You're going to get outside your statutory purpose of a 501c3 pretty quickly if you have them doing anything other than just collecting money and using it for educational purposes, if you have that 501c3 also functioning as an alumni advisory board, that's well, it's what lawyers call ultra vires. It's outside your responsibilities, it's beyond the scope of your corporation. So I wouldn't, as I said earlier, your alumni advisory board doesn't need to be incorporated. That's just a group of guys who are advising the chapter. And if you limit it to advice, you've no need to be incorporated. What are the first actual tactical steps if trying to split an all-purpose organization? Okay. I wouldn't, frankly. I would form a new corporation. I mean, you're going to get yourself, if you take one corporation and you start trying to split it up and allocate, you're probably going to have to rewrite all of your articles and bylaws anyway. So it probably would be the smartest thing just to form new corporations, fund those new corporations with the appropriate assets from the appropriate entity, and then liquidate the old one. If you want to form the tactical steps that you would take, if you wanted to do it the other way, and split it up, you'd still have to form a new corporation in order to distribute to that corporation the assets that you had. So that would be the first step. Form a 501c7 and then distribute to that 501c7, the house, and keep everything else in your existing organization. That would probably be the best way. Okay, this is more of an operational inquiry, but is there any recommendation that the fraternity has with regard to live-in advisors, house directors, house moms? You're right, that's a little beyond this. I don't personally, I've never really discussed it with anybody. I know that there are significant advantages to having some sort of an adult presence at a house, whether it's a house mom or a live-in house director or advisor, but I don't know that the fraternity itself has any sort of a policy on that. In fact, I'd be very surprised because we, as I said at the beginning, we tend to try to take a pretty much of a hands-off view on this. Is there a constitution from the headquarters for housing corporation, rules or requirements? I refer you back to one of the initial slides, which was the only 3 places in our laws that house corporations are referred to. And just so long as you have a house corporation and you comply with the filing requirements and your articles and bylaws contain the things they're supposed to contain, those are the only requirements. So those are the articles and bylaws. There's nothing nothing else required, and there's no sort of, constitution for a house corporation. That's the Constitution. The analogous document to the Constitution is your articles and your bylaws. Indiana clearly exempts fraternity leases from inclusion under landlord-tenant law. Yes. Okay. As I said, you might want to check your own states on that because you may find an exclusion there as well. As a chapter in Indiana, do we need to have our chapter rewrite the rental agreements to use the new housing agreement wording? Yes, I would. I would begin immediately, and by that I mean probably with the fall term, the documents that you're going to have them sign when they show up in the fall. It's too late now. But I would put both of those provisions in there. The one that says this is a housing agreement, not a lease. I would put in there the provision that says if you're suspended or expelled from the fraternity, you will leave immediately, notwithstanding any other provisions in this agreement. And then I would begin to I'd make those changes and not call it a sublease, call it a housing agreement. Don't call it the lessor, call it the the owner or the chapter or something like that. But get anything that smacks of a lease, I'd start to get those terms out. So yeah, there could be a significant rewrite go on, and I would recommend that you have somebody who's familiar with contracts, whoever it was who put your lease together in the first place, maybe go through some of those after you've had a chance to think some of those through. Which insurance would cover an accident on the chapter house property, such as if a member or a non-member falls off the porch or downstairs and that person sues either the house corporation and or the officers individually? It would depend on the reasons behind it. If somebody fell off a balcony because the banister broke, then then the house corporation is more than likely going to be liable. But if somebody just got drunk and rolled off the roof, then the chances are that the house corporation is not going to be involved. That's not to say they won't get sued, because a smart attorney is going to sue everybody in sight and then let God sort them out. And so you may well get sued, but the liable party is going to depend on what caused the accident. Generally, the house corporation will not be liable for something like that, unless there's like some overall failure to supervise. But generally, I think your leases are going to provide that you have an obligation to maintain the house, but the chapter has an obligation to oversee it itself. What are the differences, if any, between the following groups you've mentioned: Alumni Advisory Board, Alumni Control Board, Alumni Association? Okay, really quickly now. An alumni association is just the alums. It's just a group of all of them. Everybody who's ever been initiated into that Zeta is part of this sort of alumni association. Many chapters don't have one. They don't have a bunch of engaged alums. Some of them have a bunch of very, very engaged alums. But that's the alumni association. They're generally there to promote fellowship opportunities for alums, maybe homecoming events and that sort of thing. An alumni advisory board is specifically provided for in our laws, and so is an alumni control board. And I would refer you to the last two sections of Article 3 of the Constitution. And those will specifically describe what an alumni advisory board is and what an alumni control board is. What are the steps going forward? I'm not sure if I answered that or not. If I haven't answered any of your questions and you guys want to pop me an email, then just let me know. Are there any advantages to forming a Delaware corporation as opposed to a corporation in your home state? One disadvantage is that our laws require that you form a house corporation under the laws of the state in which the house is located. So yeah, I mean, that would be a disadvantage in that you would not be in compliance with our laws. I understand, I used to work for a Delaware corporation, even though I live in St. Louis, and our headquarters was here in St. Louis. And I know that's the way life works in the for-profit world, because the Delaware corporate law is well established, well recognized, and that's where everybody wants to be. The same doesn't hold true for nonprofit corporations. Each state has its own nonprofit corporation law and may even require that you be incorporated under the laws of that state and not Delaware. So don't get distracted by Delaware. I think that's a for-profit thing, not a nonprofit thing. Okay. That is all of the written questions. Is there anybody who's, I don't see any hands up here. I think we may have answered all the questions. Okay. As I said, this is going to be posted. This will be in the document library as soon as I find a way to get get a thumb drive over to George. If you have any follow-up questions and want to send me an email, I'll try to put them all together and get a document out to everybody. And I tell you, I appreciate your taking so much time this evening. It's been about an hour and a half, but I hope it's been helpful. And as we follow up on this conversation, we'll maybe dig a little bit deeper and get into some operational things. But I think this has given you enough to think about for now. So thanks to everybody. You can go ahead and sign off, and I'm going to conclude the call. Have a good evening.